Bismillahirrahmanirrahim. Mr. Justice Jawad Hassan, honorable doctors and the faculty, young students, young lawyers, and some practitioners. I can see Dr. Wasim, Arif Bete, Zishan, everybody is here. My law officers are here. The purpose of today's talk is on the book, and what we said yes when Dr. Ikram came to my chamber is something very important for Pakistan. I'll take 5 minutes on Islam and Constitution and arbitration. Then I speak on the Western thought. I'll today mix the Islamic Sharia law with the Western thought from where we've been trained. I will take advantage of this time to address youngsters. This book is now a gateway for Pakistan. The barometer of economy of Pakistan, when I was a corporate lawyer, like me was also a corporate lawyer, any investment जो माशियात में जो पाकिस्तान में सरमायाकारी होती है, हर इन्वेस्टर चाहता है कि जी कैसे मैं प्रोटेक्ट होता हूँ एग्रीमेंट्स पे, फॉरेन एग्रीमेंट्स, लोकल एग्रीमेंट्स. वो ओपिनियन लेते हैं लॉ फर्म से. या बड़े कॉर्पोरेट लॉयर्स बैठे हुए हैं, वो ओपिनियन देते हैं कि जी आप पाकिस्तान में इन्वेस्टमेंट कर लें, मुहादे में डिस्प्यूट क्लॉज होगी और हमारी कोर्ट्स बड़ा अच्छा काम करती हैं और इसलिए आपकी इन्वेस्टमेंट ठीक हो सकती है. नई चीज़ आती है फॉरेन इन्वेस्टमेंट, फॉरेन अवार्ड्स, फॉरेन आर्बिट्रेशन. उस पर क्या स्टांस है हमारे कोर्ट्स का, वो इस किताब में इसका जवाब है. पर्पस ऑफ दिस बुक इज़ दैट टू गिव, एंड द ब्यूटी ऑफ दिस बुक इज़ दिस बुक डजंट हैज़ एनी लॉ. It is all 267 pages, 1,106 footnotes, and I proudly say all judgments of my courts. It's a clear publisher. It's a Western publisher. I've written articles for this. This publisher has only made this book under the principles enunciated by the Supreme Court, Sindh High Court, Lahore High Court, and most judgments, recent judgments of Justice Jawad Hassan are all in this book. But I have not started my talk yet. My talk will start. I have not begun the talk. I just told you why the book is important. My talk is, the book contains the judgments, and you are young lawyers. The law under the Constitution of Pakistan is Article 70 by the Act or the Parliament and Article 89 by the Ordinance by the President and the Governor. And the other side, which is referred in this book, is the law made by the Honorable Supreme Court of Pakistan and the High Court. Ayn ki khubsurti hai, Article 189 of our Constitution says, where the Supreme Court enunciates a principle of law, decides a question of law, it shall be binding on the courts below. Article 208 says, any subject to Article 189, if a High Court enunciates a principle of law, decides a question of law, is binding on the courts below. And this is the book, a true reflection of both the articles of the Constitution, giving the principles of law, doctrines of law, the doctrines on the arbitration, as a true story. I give this book to you, 267 pages, not a single section of any law. The entire book is like an English book, all common law principles. But what is law? The law, you are all sitting here, you have fundamental rights to protection of law under Article 4 of the Constitution. It's an inalienable right of every citizen to be treated as per law, comma, no action determinative to the law, which says that the Constitution. The Constitution of Pakistan, why it's so strong? Because it starts with the name of Allah Almighty. Preamble of the Constitution starts, whereas the sovereignty of this universe belongs to Almighty Allah alone and His sacred trust. That's the start and beauty of my Constitution. Allah is sovereign and omnipotent. And Article 5 says that every citizen has to obey the Constitution, law, and the judgments of the Supreme Court of Pakistan. And that Article 4 gives you rights to be treated as per law. 5 gives you an inviolable obligation to be treated as per law. What law? My fundamental rights. Article 4 talks about citizens of Pakistan, which all the arbitration, even foreigners, and they will be protected under the Constitution. But Article 199, where we decide cases in the court, and the word citizen Individual, they're all given, but what rights? Fundamental rights. And what were the fundamental rights? Not the rights given the Constitution, right to speech, right to movement, right to life, right to religion, right to a property. Those rights are all given to me, but they are not given to me as per the United Nations Declaration of Human Rights 1948. Not given to me by the United Nations Covenant of Civil and Political 1966. They are the true translation of Holy Prophet Sallallahu Alaihi Wasallam's Akhri Khutbah. The Khutbah of Hazur Pak Sallallahu Alaihi Wasallam, Hazur Pak Sallallahu Alaihi Wasallam made Charter of Medina in 622 AD. They give duties to the Mu'min. And when you read Charter of Medina, when I spoke on the Prophet's Rabiul Awwal, I spoke with the Constitution, where Frankfurter, the American Supreme Court judges, the books are talking, the biggest lawgiver in the world is Prophet Muhammad. On the 50th anniversary of the United Nations Declaration of Human Rights, acknowledged, the Hillary Clinton, then the Foreign Minister, Foreign Secretary of US, acknowledged that the entire fundamental rights given to the world was not Magna Carta 1218. Not Petition of Rights 1772, not the American Constitution, not the United Nations Declaration 1948, it's the Prophet Muhammad Sallallahu Alaihi Wasallam's right last khutbah. That is the Constitution, that is the law. I've given a judgment where I tried to develop the constitutional civil law with the Islamic provisions of Sharia and Islam, PLD 2020, Lahore 229 Ahmed Pansota case, where I tried to bring the concept of Islamic Sharia with the Western concept of constitutionality as Antonio Scalia, as the revisionist approach of the Constitution is derived by Lord Sumption recently by the England. The word arbitration in Islam is mentioned as Sulah. The first arbitration was by Prophet Muhammad Sallallahu Alaihi Wasallam, Blackstone issue. There was a dispute. Every Quraysh said, we only and only trust Holy Prophet Sallallahu Alaihi Wasallam. इन्होंने किताब में लिखा है अकराम उल्लाह साहब ने कि misconduct of the arbitration can only be done when you are corrupt and you're not honest, when there is an issue of bias. The only beauty of the first arbitration is every society said we trust Prophet Muhammad. वो एक चादर में उन्होंने वो दिया, उन्होंने कहा जी आप डिसाइड करते हैं. That is the first arbitration before Islam, and the arbitration in Islam, जो हम कहते हैं United Nations Declaration of Human Rights 1948, वो वेस्ट कहता है, हम कहते हैं हुजूर पाक सल्लल्लाहु अलैहि वसल्लम आखिरी खुतबा. वो कहते हैं ट्रीटी ऑफ पीस हेग की, मैं कहता हूँ सुलह हुदैबिया. That was the first arbitration between two countries. This is how old the concept of sulah between two persons are. What is arbitration? Arbitration where you have an agreement between each other. Everyone wants to be protective about his interest tomorrow to have a dispute, and arbitrator decides the matter. Local arbitration और फॉरेन आर्बिट्रेशन. फॉरेन आर्बिट्रेशन मेरा एक आर्टिकल है, अगर आप पढ़ लें इसमें सही बात जो मैं कहनी है, 2018 CLD जर्नल पेज 17 पेज पे आई हैव गिवन द होल कॉन्सेप्ट. व्हाट आर्बिट्रेशन इज दैट हम जो ये चीज़ कर रहे हैं, जज साहब की जजमेंट भी है उसमें, वो जो थी आपकी वो फॉरेन आर्बिट्रेशन का आखिरी मेरा जो 5 मिनट हो गए, आई विल बी टॉकिंग ऑन द फॉरेन आर्बिट्रेशन as the perspective of the chota c, bada c, how do we bring the foreign arbitration element. But issue here would be the, जब हम मैंने उस आर्टिकल में मैंने बड़ी अच्छी बात लिखी है, वो 2018 CLD जर्नल पेज 17, जहाँ मैंने खुद लिखा है एज अ जज कि जी my perspective of arbitration as a lawyer was different, but today I'm a judge. I have to look at, but I'm a face of Pakistan. I'm a mirror of Pakistan. I cannot do anything which will stop my investment. Everything in Pakistan, anybody investing in a business, domestic or foreign business, they will only go to a lawyer to draft an agreement. And if you see a weak country with a very weak courts, then nobody will invest in your country. हमने commercial court establish किए पंजाब में, and my first thrust was the arbitration clause. जो हर इंसान ने अपने आप को प्रोटेक्ट करना होता है, और आर्बिट्रेशन अगर अच्छी है उसके अवार्ड्स नहीं होंगे. एवरी चैप्टर हैज़ अ ब्रीफ एंड कंक्लूजन एंड इट डिस्टिंग्विशिंग बिटवीन टू आर्बिट्रेटर्स. two laws, 1940 and 2011. The first chapter is the legal anthropology of the arbitration. Anthropology is you trace down how it has impacted sociologically, psychologically to a society, and the book says it traces an arbitration, not 1940, an 1899 act. And the Justice Rohinton Nariman, the Indian Supreme Court judge, a Parsi judge who was one of the brightest judges of India, who retired, and I was hearing one of his reading an article, he mentioned that even the Panchayat system, before the arbitration came in a village, they had a trust to resolve the dispute. Why do people come to us? Because they think when they come to us for a dispute, and courts decide the matter. And that the English judges in 1934 Privy Council, page 105, have examined the role of Panchayat in the villages. A trust on a person in Panchayat was a very strong bond of a society. Even the West has acknowledged the concept of Panchayat. And he has traced down the concept of legal anthropology of the Arbitration Act of 1940. That act provides a domestic arbitration. हमारा टॉपिक ज़्यादा है फॉरेन का आ रहा है बिकॉज यहाँ सारे मोस्टली लॉयर्स बैठे हैं उनको फॉरेन का ज़्यादा इंटरेस्ट है सुनने का बिकॉज दैट इज मोर इंपॉर्टेंट टुडे बिकॉज 1940 एक्ट came back and we have all the judgments of Rupali, Hitachi, Okhad, Uzeen, and all judgments are coming to Pakistan. Or in 1940, okay, we go to an agreement, we have one arbitrator, three arbitrators, with the intervention of the court, without intervention of the court, we file the rule of court. When we file the rule of court, that can be set aside on the ground of misconduct. Misconduct can be a biased person, a corrupt person, a award has been nullified, things can be nullified. But those are the established principles. I'm not going to talk more on that because today my talk is on the foreign arbitration. The first time Pakistan never ratified the New York Convention. The 1940 Act was read with the 1937 Protocol of New York Convention where you can bring out the cases. Pakistan, as you know under international law, any convention by the United Nations, if you do not sign it, you don't become a party. If you assess it, you become a party. And sometime Pakistan ratified that convention. That is called New York Convention 1958. वो कहती है दुनिया में जब कोई मुल्क एक दूसरे के साथ या कोई एक बंदा एक मुल्क का दूसरे मुल्क के साथ कोई एग्रीमेंट करेगा उसको हम फोरम देंगे कि उसका कोई डिस्प्यूट होगा उसको उसके मुल्क पर ट्रस्ट नहीं है उसको उसके मुल्क पर ट्रस्ट नहीं है हम एक फोरम देंगे एंड थ्री थिंग्स आर लुक्ड इनटू आर्बिट्रेशन द वेन्यू ऑफ द आर्बिट्रेशन कहाँ पे सीट द फोरम ऑफ द आर्बिट्रेशन दोज आर इंटरनेशनल चैम्बर ऑफ कॉमर्स London Court of International Arbitration, those are DFIC and all forums. I've been doing various international arbitration before I became a judge, and Mir Sahab was also, Judge Sahab has done a lot of arbitrations for Pakistan. Those are where you go abroad and present your case, and the award is called a foreign award. When it's called a foreign award, it's not hit by a civil court, or it's not hit by the grounds which are taken by the other 1940 Act. You have to divide the arbitration before the foreign arbitration and after the foreign arbitration. And the legal anthropology is Pakistan never signed that treaty of 1958, New York Convention, but then in 2005, 7th of July 2005, we, after ratifying the New York Convention, we promulgated the ordinance called Recognition of the bracket में foreign agreements and foreign awards, bracket close, 2005 ordinance. It lapsed, it came back. It lapsed, it came back. First case in that I fought against a foreign bank for local company. And I framed the issues, the Shamil Bank case. Before this is Asma Said. On the one ground only. Because New York Convention, Article 5 says you cannot challenge an award. At that time, I must change, I will not do such thing now. I will go and enforce the award. I was a lawyer. I was a young lawyer. I needed to develop jurisprudence. My ground was, my lord, the language was English, not Arabic. It was in Bahrain. My lord, it's against the public policy of Pakistan. Public policy is under Article 27 of the Contract Act. So public policy is that they had the agreement, that's the whole concept of GCC. And I brought the issues, framed the issues. That case was then relied by Jess Smith case. Jess Smith case was then brought up by a law firm in Lahore, and that was, after I became a judge, issue was 7th July 2050 को Foreign Award Act came. Then we enacted an act called Foreign Arbitral Recognition of Foreign Act 2011. That day was 17th of July 2011. Now, whenever any cases are before, Honorable Justice Mir Hassan Aurangzeb has decided some cases under the foreign where you have to draw your line. All grounds of 1940 are not available to you. You can only, when the award is finalized in Dubai, even I was doing an arbitration of 2 companies in Lahore, but we chose Singapore under ICC. The award is still called a foreign award. Venue, forum, seat of the arbitration. Because that is the concept where the Supreme Court in every big cases has come out with the concept that we have to look at the cost, we have to see the party's behavior, we have to see the seat. And un sab ki judgments are all mentioned in this book. Book has chapters, and those chapters has even discussed every regime. और जो अच्छी बात है इस किताब की जो मैं कहूँगा, that Dr. Ikram Ullah has mentioned in 14 chapters by distinguishes 1940 Act with 2011 Act. Every chapter he has discusses, like the chapters in the book relates to the governing laws, the topic of concept of arbitrability, the interpretation of the agreements, the power of the arbitrator, stay proceedings, enforcement proceedings, these proceedings, and as you know, all have agreed, but we cannot interfere in a foreign arbitration. We did try, Umar is sitting here, remember we did try for one client to stay in arbitration of London from Islamabad High Court. We were partly succeeded, but the Bakshi case of McDonald came, which in India, some foreign arbitration award, the foreign arbitration was started in London, and Bakshi was the person against McDonald. He took a stay order from Delhi High Court. And that stay was vacated because you can only challenge the foreign arbitration in the jurisdiction where the arbitration is being held. That's the Aaron Steele case. Now the UK Supreme Court has also, if you need to stop an arbitration in London, you have to go and work the courts in London. Not in the country where the parties are residing. In the Bakshi case, McDonald, India, 2015, AIR, Delhi, the court held that although parties are within the jurisdiction, they can stay, but they don't know. The law of foreign recognition of Foreign Arbitral Act 2011 has 2D, which says court. Court means a high court. 3, you enforce the award to a court or the agreement issue. 4 is the recognition issue. You can only object to the arbitration award or the proceedings as per Article 5 and 6 of the New York Convention 1958 as a schedule of the Act. That is also, and also one issue which is now pending is a Chota C, Bada C. You are also hearing it, I am hearing it, I don't want to comment on that. We will see which way. And there are so many issues, that's why it's an open debate. Anybody who wants to know how strong is Pakistan for economy, I say, when you read this book, you get the answer. The courts in Pakistan have favored the sanctity of the arbitration. The courts in Pakistan have held in favor of the contracts. The courts in Pakistan has very less interfered in the arbitration proceedings. The courts in Pakistan, nevertheless, in the a local award or a foreign award, has always ruled for the rule of law. As to conclude my talk, the rule of law has 3 components: access to justice, dispensation of justice, and administration of justice. Under the access of justice, under the rule of law, as per Article 37D of the Constitution, state shall provide inexpensive and expeditious justice. I must say, under Section 20 of the 1940 Act and Section 3 of the Recognition 2011 Act, we have courts. We have courts which are under Chapter 2 of the Arbitration Act to the intervention of the courts, without intervention of the courts. Under Section 2D, my lord and myself are appointed as judges of the foreign award, because the word used, 2D, is a judge of a high court nominated by the Chief Justice to decide the cases of the foreign award and enforce or the agreements. The access to justice, Pakistan has fulfilled that. Dispensation of justice, if somebody here listening from foreign country, I will say all judgments under the Foreign Arbitral Award Act 2005 Ordinance and now 11 Act. It's almost 17 years of that law. All have been enforced. No foreign investment or any case against any of the sanctity of the foreign award or the agreement. And at the end, 4 months ago, we were speaking at the webinar of Oxford University with Justice Bashir Alam and myself. We were speaking on the arbitration matter of ADR and the concept of commercial courts, where Justice Bashir Alam has authored, and after that, a day before that, webinar in July 2021, Justice Bashir Alam has authored one of the leading judgment on the Foreign Arbitral Award, upholding the Lahore High Court Division Bench view of the case of a foreign award being enforced at the High Court, and the other party were taking a benefit of a judgment of our court, saying that foreign award is a local award, the Taisi one. That judgment clarifies the whole concept, and that is how Supreme Court of Pakistan finally has also railed a good judgment on the act. And I must say, you should all read the book, although the book is very expensive, 35,000 rupees ki kitab hai ye. But law firms can afford this. You can get a photocopy of this book. And as a judges, we felt proud to know that today in Pakistan, a book can be made single-handedly on the judgments of my elder judges of a Sindh High Court, Lahore High Court and Supreme Court. Thank you.